What is happening, everyone out there? What is happening, my global community? We are so live and we are so back, and this is Inside Law with your host, Brookshire, yours truly. So, today we have a very, very interesting show. And now I say this every show because I really do believe that. I find the law and understanding the laws of the land to be very, very interesting. And I think that anytime that you go into any part of this land, you too should know those laws because they do, in fact, impact you, whether they're actually impacting you directly as you're consciously thinking about them or indirectly. So, this particular attorney that I was have had the new pleasure of meeting is just a fascinating individual. When I tell you, I've listened to other interviews, and it reminded me of Angela Davis, that black intellect, that smarts. And then 30 years in the game, she has been practicing law. And all areas of law. I mean, from the cannabis industry to immigration to landlord tenant law, which that's a factor, a sweet spot of mine, to criminal law and civil law. I mean, from a gambit, even entertainment. She has her hands in all areas, and so it is a treat and an honor to be able to have someone on with such a broad perspective of talking about the law. And it's going to be definitely a treat for anyone out there, my pro se litigants, that means you're self-represented, to my new attorneys, old attorneys. I mean, just a refresher. I'm excited to be able to invite onto the stage this beautiful attorney, this young lady that has been out here making a difference in the law. I would love to welcome Miss Ronda Dixon to the house. Miss Ronda Dixon, are you there?
I'm
Welcome to the
here.
house.
Thank you. That was a great
Welcome to the show.
introduction. Thank you.
I am so excited, as I said before, to have you on because, as I said before, I was recently listening to something that you've done on uh, what it was. The name just slipped from my brain, but you did on history recently, and you were talking about Hamilton. And tell us the title of the
Oh,
show. Was it Works?
well, it was woke, wealth of
Whoa,
knowledge and
yes,
experience.
whoa! I knew I had a
Yes,
W in there.
right.
Um, that is I really appreciated that, you know what I'm saying, and sitting back and listening to you talk and the knowledge base that you had. So I just want to kind of just jump in to you. Where does this all come from? Tell us a little bit about where you came from, your childhood. Who are you a little bit?
Well, I was born and raised in South Central Los Angeles, so I have deep connections to my community. I have traveled a lot. When I was a little girl, my parents took me to Vietnam. I
Oh,
call my
wow.
mom the CIA secret weapon because my father apparently went there to help out with communications lines. Remember those big Motorola phones that people used to have?
Oh, wow, yes.
They were actually military. They were what they called in the airstrikes from. So
Mm,
what happened was he was doing this testing the lines in northern Thailand, and
mm.
my mom found out. She called. My mom is very fair, so she goes in and she talks to the State Department and says, "My husband left me. It's the '60s that you just didn't do that." So they went and found him and connected her to the Pentagon,
Oh,
and he
wow.
said that he was in a tree up in um, northern Thailand, and he was testing the line, and he almost fell out of the tree when my mom's voice came on the phone. She said,
Wow.
"I'm coming out there and I'm bringing the kids." So she brought me and my brother out there. So we lived in Southeast Asia for 2 years.
Oh, wow.
And it was a very eye opening and interesting experience because we actually went to Saigon during the Tet Offensive and played with little kids that had amputated arms and legs from having been the victims of the war, stepping on IEDs, stepping on bombs. Because to this day, they've planted so many bombs in Vietnam that people that are tilling the fields can accidentally step on one and activate it.
Wow. And they're still like explosive to
Yes,
this day.
yes.
Wow, that is so. Now, how did your childhood, or how would you say your childhood shaped where you are now? I'm sure everybody goes back and says, some of the issues that they're dealing with stem from their childhood, but also their successes as well, too. Explain how you feel yours does that.
Well, interestingly enough, after being 5, 6, 7 overseas, then I come back to Los Angeles. I'm in South Central, and I find two dead bodies that are overdosed on heroin. The heroin epidemic is a big deal. Um, just growing up in that area made me aware of a lot of the social issues. So later on, I did work for the DA's office for a while. I became an entertainment lawyer. And after having a successful career at that, I decided to give back to my community and set up a substance abuse clinic on 48th and Crenshaw, which is really in the heart of the community. And I served a lot of people and helped a lot of people recover. And it was interesting because a lot of people would say, well, Miss Dixon, how are you able to connect with these people? Because I didn't do drugs. And they were like, how do you connect with them? And it's because I grew up in the neighborhood and I was so exposed to it, and the harm that it does to people, and the systemic racism, because basically the war on drugs was a war on African American people. And I was able to witness that firsthand. And that was just another thing that they did to us, which was to bring the drugs into the community. And that's something they've done before. They did it with the Chinese, with the opium wars. This is how they take over and colonize. You know, you can colonize people's mind. You can colonize their culture. And that's what has been done.
That's interesting. So, okay, so take us to law school, or this. What made you decide to want to become an attorney exactly, and then take us to law school. That time frame of what was it like picking which law school you were going to go to? Take us back.
Well, you know, it was really funny. I actually wanted to be a writer, but I ended up being a lawyer because I said when I was little, you couldn't make money by talking, like rapping. You made it, you know, by talking as a lawyer. And I had to talk my way out of a lot of things when I was in South Central because they loved to fight and they would always start something. And I would always be able to talk my way out of it by, you know, basically, you know, fast talking them and telling them off. And they'd be like, oh, wow, they couldn't beat me. Like sometimes I tell people having a PhD in a Juris Doctorate degree is like a PhD in argumentation. It's like coming to a gunfight with a knife if you want to argue with me. You know, you're not going to be equipped to do that.
Nice.
And my experience in law school was there was only a few blacks in law school, and that's been the case. I went to UC Davis Law School, and I actually had to transfer in, and I think they maintain about 4 to 5 black students. And it was so interesting because the Bakke decision was in UC Davis, and it had to do with the veterinary school. And at that time, they said that having a set aside of so many seats for African American students was reverse discrimination against this guy Bakke. Now, I had a situation where I clerked I did an externship for a federal judge in the Eastern District, which is the federal court in Sacramento. And there was a white guy saying that this black guy took his seat. And I said, well, really, tell me what happened. He said, well, this black guy got a seat in Berkeley and I'm at UC Hastings. And I said, well, so I know for a fact there's like 25 black people out of 500 that are at Berkeley right now because I'm in the boss of the Black Law Students Association. I said, what about the 500 and what about the 475 white people that took your seat? Why is it that you have to target and say that this black person didn't deserve a seat? And that's basically the argument that they have, is that if you had said all 500 seats go to white people, then I would have gotten the seat as a white person. But I said, but there's thousands of applications to Berkeley, thousands. So why would you have been selected out of those 500 anyway?
Right.
You know what I mean? But this is their reasoning. It's just like, let's just find a black person and say, oh, they're not qualified. I should be more qualified. And right now we have Prop 209 came in right after that in 1996. Prop 209 came in, and that really was devastating because the first year of Prop 209, there was only one black person and one Hispanic person in the entering class at UC Berkeley Law School.
Wow.
Based on them being able to look at race, obviously they decided that they weren't going to bring in black people, and it's been devastating to the law school classes. Now we're talking about, we have a Prop 16 that is on the ballot coming up in November. That is going to bring affirmative action back because it's done a lot of harm because it's been proven that when they can look at race, they are discriminating. because
Wow.
the people that are getting in, that one person was magna cum laude. People don't go to law, they don't even apply to Berkeley unless they're magna cum, summa cum laude. So
Wow.
if they're not, they know it's very competitive. So that means that there were several people that would have been able to get in, African Americans and Hispanics, that were turned away just because of their race. It had to be, because
Hmm.
there's no other explanation for it.
Hmm. So now, did you complete the entire term of law school? Did you get out early, or did you go the entire time? How was that for you?
I went the entire time, and I started out because I didn't have the money to go to law school. I started out going to night school at Whittier
Oh.
Law School, and I worked at the DA's office during the day.
Hmm.
And it was a race to beat the clock because Whittier had this situation where they would lock the doors of the law school at 7. And if you had three tardies, you had an automatic fail.
Oh,
And the
wow.
problem is that as a law clerk in the appellate division, I had to run around to the courts after hours. I actually had a badge, and I had the ability to go in and stamp our documents after hours so that they would still be considered to be entered on that day. So, like, after 5, I can still go to the court, stamp them. But in LA traffic, I'm driving to all the appellate courts and then rushing over to get to class. And many times I just squeaked in there just in the nick of time.
Wow.
Yeah.
That,
So,
that's very interesting. So now I want to get into your knowledge in the appellate field in a little bit. So now was your first job as a lawyer? Take us there, because I know you were clerking and you were doing things in the field as a student, as a law
yes.
student. So where did you decide to actually get your first employment gig once you had your degree? And then I want to go back to you actually taking the bar and how that was. But I want to talk about your first job first.
Well, it was tough to get the job in the area that I wanted. I actually was working I was an office manager of a small agency, talent agency during law school.
Okay.
And I knew I wanted to go into the entertainment area, but it was very difficult to get into. First of all, I started with criminal law. I didn't really want to do criminal law in the beginning, but it was just the low-hanging fruit, and then it gave me an opportunity to learn about trials and things like that. So, and I was fascinated because when I started at the DA's office, there was some high-profile cases. There was the McMartin Middle School, which was a child molestation case that was all over the news. And then there was also the Landis, where he was shooting a movie, The Twilight Zone, and two children and Vic Morrow, the actor, they got decapitated. And that was two cases that I worked on. And they were really fascinating because in the case of McMartin, that was my first day on the job. I asked the other law clerk, there was only 2 of us in the appellate division, and I asked him what exciting cases did we have, and he told me those 2 cases, and I said, "Oh my God, the McMartin case!" I said, "The one where he molested all those school children. It's all over the news." And he said, "Yeah, but he didn't do it." And I go, "What? How do you know that? We haven't gone to a trial or anything. How do you know he didn't do it?" He said,
Right.
"Well, here's all the evidence. We're doing all the pretrial motions, so you get to read it, you listen to it, and see what you think." And I did. And that was my first day. And I just listened to all day long that day. The second day, I listened to all the children's interviews. I read all the transcripts. And I go, wow, well, why are we prosecuting him?
Right.
And he said, because it's an election year for the DA. And
That's
I'll tell you that what really happened was they look for the usual suspect. He was the type of person that on Friday night, he's going to be at home. He's not going to have an alibi. He was kind of weird. There was a picture where he was wearing some, you remember, do you remember those shorts that they used to wear, the jogging shorts?
mm-hmm.
So it's a picture where he's posing with the team. He's wearing some jogging shorts, but his stuff is hanging out.
No.
He doesn't know it. And they use these things against him, but actually he didn't do it. And they ruined that family's life.
Wow. I just, as a sidebar, I find it interesting. I've never heard anyone say the typical someone that wouldn't have an alibi because they're home on a Friday night, like
Yeah,
that, as that being something that they, if they have some sort of malicious intent, or let's put it on this individual, this person is always home, which would be, you would think, I'm home, that's a great
yeah,
alibi. But actually, no, it's not, because we don't know if you're home.
right.
Wow.
Social misfit, basically. And that's a sad thing because if you look at the murders that were happening at that time, look at Kenneth Bianchi. He was very handsome. He was the Hillside Strangler. Nobody even thought to look at him because they thought, well, what, he wouldn't have a problem getting a woman. No, he didn't. And
Right.
that's how he lured them in. Him and his cousin. He was handsome, and they had a truck, a carpet laying truck. And what they would do is they would give women rides, young girls. Some of them were really young. And they would give them a ride and say, oh, yeah, sure, you need a ride. Come on, get in here. And then they would torture them with the tools that they had in the back of the,
Wow.
yeah, it was terrible. It was heartbreaking because they recorded what they did. And in the trials, they played the recording of these young girls in agony for hours. They tortured them for hours. And I used to wonder, this is before I became, worked for the DA's office. I used to wonder, why is it they know immediately that it wasn't the Hillside Strangler? They had all kind of copycats going around strangling women and leaving them on the hillside, but they knew immediately that's not the Hillside Strangler. Why did they know? Because he had a very specific MO. MO means modus operandi. It means the way that they operate. His MO was that he took a coat hanger and some pliers and slowly twisted it over hours to asphyxiate them. And that's how they
Wow.
knew that it wasn't, other people would use a noose or a belt or something, but they knew immediately that they didn't use the same modus operandi that he did.
The one thing that I have found interesting in listening to other things that you have put out there was your stories of your
Mm-hmm.
recanting of the experience. Because a lot of times you don't hear a lot of attorneys do details and recanting their experiences and the things of that nature. And so I appreciate yours. Where obviously you're getting in the DA at an early age and you're learning these things. Is there ever a time that you become numb to the craziness that you have to deal with in that space?
I'm sure other lawyers do, and I'm sure district attorneys do, and prosecutors do. But for me, and maybe even public defenders, but for me, I'm an empath, and it was heartbreaking. I had one of the cases that I had to do was they had a constitutional challenge to the jury pools, stating that they were usually stacked. They would, most of the time the prosecutor would eliminate. They have these when they do voir dire, which
Right.
is when they go in and choose the jury. Their pos- their policy would be to get rid of all of the minorities if there's a minority defendant. So you were
Hmm.
facing an all-white jury most of the time, and that was prima facie bias.
Right.
So they were in, and since then they've changed the laws. But this one person had a constitutional challenge, and I had to go to all these courts, and it was so interesting because I had to serve what's called a writ of mandate on
Hmm.
these judges, mandating that they give us all their information from all of their jury selection. And it's interesting now, maybe as a result of that case, they destroy everything regarding the jury immediately after the trial. They do.
Wow.
All the notes they took.
All right. I want to get into that a little bit too, within the appellate aspect. But just quickly, how do they do that if there is potential for appeals? And sometimes these things can last for years.
Yes.
Depending on the criminal type of case.
So a lot of us lay people don't understand. So I used to also work for the California District Attorneys Association, which is a nonprofit agency that we wrote the prosecutor's brief, the DUI handbook, and we also lobbied for laws that help the prosecutor. So a lot of this helps the prosecutor. Like, for instance, in a preliminary hearing, you can have just the officer recite his report, which is hearsay. And that will be enough to bind you over to a trial. And the conventional wisdom is that you don't show your hand because the prosecutor has the burden of proof.
Right.
So you don't want to tell them anything about your defenses. You don't want to give them anything. It is their duty, though, to give you every piece of evidence that they have against you. And they have to give it, especially if it may be exculpatory, which means that it might be something leading to not guilty. They a lot of times will hide that. They've been caught doing it quite a bit. And there's been, in recent years, there's a lot of laws against prosecutorial misconduct. And a lot of lawyers can go to jail for that. They disqualified the entire Orange County prosecutor's office a few years ago, like 2 or 3 years ago.
Oh, wow.
For doing that, for systematically withholding evidence.
That is very interesting. So we're going to let's put a pin because I want to come back to some of these things. What would you consider your sweet spot in law?
That's a good one. I really loved when I was doing entertainment law, but that was another one that was tough. To be honest with you, it's a very misogynistic business, law period. And you won't find a lot of women in the upper echelons of any of these companies. And as far as lawyers are concerned, it was very tough to get in. There was a lot of competition. But interestingly enough, I would always be very aggressive in negotiating contracts. I felt really bad for the artists and the entertainers for the fact that their work was necessary to these companies, but they really treated them like slaves.
Wow.
They should be paid well. I mean, sports people are paid a lot better than some other people, and that's because they fought for that. And even in the case of movies, they get paid a lot better. But in the case of recording artists, they get paid very little. And it's very heartbreaking to see people that are so talented, living on the streets, not able to sustain themselves when they made money for these companies. I mean, lots of money. You only have to look at their balance sheet versus the artist's balance sheet. Now, if you have to have art in order to make your money,
right?
Why is it that these artists are mostly broke and these companies are so rich? And it's all of the United States because it's greed. It's unbridled greed.
Well, let me ask you this question. Let me ask you this question in that space. How much of the responsibility is it for the individual? Because that can relate back to even in a civil case or a criminal case. And how much of the responsibility is it on the party to understand what they're into, understanding the laws versus just hoping that an attorney does it for them? And is it beneficial for them to be smarter to help the attorney? I've seen it both sides. What are your thoughts on that?
Well, undoubtedly, it's beneficial for them. A lot of times I would give my clients a book, All You Need to Know About the Music Business by Don Passman. And I wanted them to be able to have intelligent discussions with me when I talk to them about their deal, because they need to participate. A lot of them don't know anything about the business and they think that's a bad thing. They think it's taboo. I just want to stay strictly art. I don't want to know anything about that. But that's when you get taken advantage of.
Right.
The great ones knew about it. I mean, you talk about Prince, you talk about Madonna, you talk about Michael Jackson. They knew the deal points. They actually did know the deal points. They might act like they didn't because that was just an act. They knew what they were doing. And they were able to advise their advisors and have intelligent discussions with their advisors. But unfortunately, the average artist doesn't. And there's a power dynamic, though, that is just so unbalanced that there is, no matter how much they know, they have to hope to have an attorney like me, number one. And number two, they have to have bargaining position and somebody that knows how to exploit that. Like in the case of an artist named Shaggy. Initial offer for him was $35,000. He ended up with $1 million. I was his attorney. I was wet behind the ears, but I knew that $35,000 wasn't good. I knew that $75,000 wasn't good. I knew that $150,000. They literally have, even though they say it's an unspoken rule, at that time they were giving certain artists certain types of deals. And I would always tell them, look, my artist, I want you to think pop, think white. Don't insult me by giving me these numbers that you think that African American artists are supposed to get. And because I'm just going to say no, no, no. And that's what I did. And eventually, if they want the artist, they will come to the table. And if it's undeniable, they have to come to the table. I mean, Shaggy's record was doing really well in the foreign territories, and they look at records and look at other English-speaking countries, and they say, okay, if it does well in England, if it does well in Australia, if it does well in Canada, it's probably going to do well here in the U.S. So they monitor that. And we broke the record, actually was broke in New York in the local market, but then it moved over to London. And once it went to London, he was on top of the pops 5 weeks in a row. That's like their beginning. That's before, American Idol. And as a matter of fact, Simon Cowell called me. I didn't know who he was. And we were in the middle of a huge bidding war. So I picked up one phone and he goes, okay, I would like to offer such and such. And I said, well, we're at like 275. What do you want to offer now? Because, okay, the phone's ringing on the other side. So the phone rang on the other side. And I think it was a guy named Peter Edge. And he said he doubled it. He doubled it. And he just went from 275 to 500 and something. I go, whoa, okay, let me talk to him. And I hung up on Simon, and he wasn't able to get back to me, but I'm sure he would have offered me more. But, it was just moving so fast. And I just said, look, I got to get all the money that's on the table. And I have another thing I always say is it doesn't stay very long, so you got to grab it. So when we got the $1 million offer for Virgin Records, I got on a plane. That was at 10 a.m. on Monday morning Pacific time that I got the call from the managing director of Virgin Records. And when he said he was going to pay $1 million, I had a deal point, and I asked him for all these different things on my term sheet, and he was giving me everything. And then I just put it down and started asking for outrageous stuff, and he was yes, 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 yes. And I was like, oh, okay. Well, this sounds like something we need to do. And by 3 o'clock that afternoon, I was on a flight to London. By 10 a.m. the next morning, I was in his office. And that was significant because remember I told you it's really cutthroat. When I got there, another attorney was on the line claiming to represent Shaggy.
No.
Yes. And so I was he had done that before in the Island Records too. But interestingly enough, I was on the phone. I was actually in the office with Ken Berry, with Robert Livingston, the manager, and Shaggy. Orville Burrell is his real name, but Shaggy. And so we were all in the office, and we get this call, and it's on speakerphone. And this other attorney, I'm not going to name him because, I don't want to get in trouble, but he says, he starts talking, and his client comes on the line. His client didn't start out on the line. So his client says, we have to hurry up and make this deal before Ronda Dixon gets there. And he says, he said, you weren't here at the beginning, so let me start again with the introduction of who is actually in the room in London. And he said, please introduce yourselves. And I go, Ronda Dixon is here. So, yeah, he was pretty embarrassed by that. So
that's very interesting. Okay, dope. And so ultimately, what happened in a situation like that? Did he just hang the phone up, or did he? What did he say?
Well, the thing is that Shaggy was on his record label, but he had no contract with Shaggy, because what they used to do in those days was they really took advantage, especially Jamaican artists. There was no Copyright Act in Jamaica at the time, and they stole Bob Marley's catalog and a whole bunch of people's catalog because there was no Copyright Act. Number one. Number two, in the case of he paid. So what they used to do was they used to get the producer, and they used to say, bring me a record. And remember, in the Jamaican, a lot of times they'll use one beat and have Elephant Man, Buju Banton, everybody, all the top artists will jump on this track. Okay? Right. So they thought the producer was the important one. They thought that if they paid the producer $1,000 to bring them a track, and the producer would turn around and pay somebody like Shaggy $200 to voice the music. And that was it. No paperwork at all. Now, in the United States, the Copyright Act says, Section 106A, no interest in copyright shall pass without a writing. So I used to always explain to people, as long as you don't sign anything, you still have 100% of your publishing. Don't sign anything. A record deal, nothing. Nothing they put in your face. Do not sign it. Shaggy hadn't signed anything. And I was comfortable with knowing that. So I knew that
How do
I
you get
had,
around that though?
pardon me,
How do you get around not signing when your name starts getting big in these opportunities? How does someone
get
get around?
around it? That was a blessing. He hadn't signed anything, so he retained 100% of his rights.
I get that, but like usually people want you to sign things so that way they
Right.
have the right. So how do you get around? Is it just timing at
We
the time?
didn't get around it. We signed a deal for $1 million.
Gotcha.
When we had a chance to, we signed for $1 million. We didn't sign for nothing. You know what I mean? That's what they want. $1 and other good and valuable consideration. I'll give you a case in point of another one. Um, I'm doing, my thing, and one of my clients is at a record company in New York, and they're notorious. They have all the Jamaican artists are on their label, and they take their publishing and they don't pay them anything. $1 and other good and valuable consideration, they say, and they don't even give them the dollar. So I have a guy. He's in the lobby crying, and one of my clients is walking through the lobby and says, "What's wrong, man? What's wrong?" He goes, "Man, I have this track, and they don't want to give me nothing but $1, and I know it's worth something. I know it is." And so he said, "Well, why don't you call my lawyer?" So he gives him one of those big Motorola phones.
Mhm.
He calls me, and I just like to, spar with him anyway. So I don't even know this guy, but I said, "Okay, who's on your track?" He says, "Elephant Man, Chakademus and Pliers, Bujuba." I said, "Say no more. You got a lawyer." I said, "What I need you to do is go back upstairs and talk to the president. And when you talk to him, tell him that I'm your lawyer, and whatever he offers you after that, do not accept it. I repeat, do not accept it, because I will get you more. I guarantee it." He calls me back 10 minutes later. Remember, he had been crying before. He's laughing. And he says he went up there and talked to him, told him I was his lawyer. He goes, "What's?" He said, "No, man, you don't have to do that, man. What do you want, man?" And he said, "Oh, she said you would say that, so I know I have the right one." So that song happened to be a song called "Give Me the Light" by Sean
Oh,
Paul. But that song, actually, Sean Paul wasn't even known. He was on the track with all these other well-known people. And 2 years later, because I was able to preserve his publishing, because otherwise he would have signed the publishing deal with them. Because that's how their record deals always tie everything up with the publishing. And that's where the publishing company, the record company is always the poor relation to its publishing company.
hmm.
Because the publishing company doesn't have as many expenses as the record company does. So eventually, the publishing company outpaces the record company in money. It
Hmm.
actually ends up making more money. So they knew that, and they would always take people's publishing by putting a
Wow.
clause in there saying that it's a work made for hire. It's a very innocuous little clause, just a few little words, but those words take all your money and all your rights away.
Wow. Now do you feel like in the entertainment the focus is around music? Because I've talked to entertainment attorneys that feel like they want an entertainment attorney that is focused on whatever that niche is in entertainment. They don't necessarily want them doing this and that and all other types of things. They want, if it's books, we want you to be focused on books. What is your thought? Because you are talented at multiple things, do you need a niche or do you just need a person willing to fight for you? What would you say to someone?
You need a person willing to fight for you, and it depends on our knowledge of the area. I do television and film too. The A lot of attorneys won't shop things. I used to shop things for people, because a lot of times what happens is if you don't have an agent, you can have an attorney, and that's what Chris Tucker did. I mean, he actually bypassed the agent, and his attorney did all of his deals. Um, you have to have somebody that's dedicated to you. The way it works, it's a very difficult business. It's difficult because people will go and get a manager to assist them with their agent because they don't think that they don't think their agent is actually working for them. So they go get a manager and pay them 20%. The agent is paid 10%. They have a business manager that pays 5%. Attorney that's paid 5%. You do the math. How much money is left over? And this is in the area of television and film. How much
Right.
money is left over for the artist, for the person who's the actor? Not much. And that's why, you have to try to be aggressive and do deals like, let's say the deal that Oprah Winfrey got. Nobody wanted her. And that was a blessing. Same thing like with Shaggy. Nobody wanted her in the beginning. So she just said, okay, I'm going to do my own show, put my own money up. And then when it was time to sell the show, major networks didn't want it. So what did she do? She syndicated it. Now, how does syndication work? There's no money up front, so therefore it's not hard to sell. What happens is a syndicator, like King World, which was her syndicator, they retain the rights to the national commercials, like the McDonald's commercial, the car commercial. But for the local market, like the pool company, the Cal Worthington and My Dog Spot type of commercial that's really localized, that belongs to the local station. So because they split the advertising revenue, that's how that deal is done. And that's why she's a billionaire, because she got the advertising revenue, which is exactly how networks work. They work based on the advertising revenue.
You know, that's very fascinating. Does that still work?
It works even better now. Now that we have the digital world, we're back at the beginning of rap. Remember when nobody wanted rap music? When NWA sold a gold record actually underground without getting played, because you couldn't play F the Police on the radio.
Right.
And they didn't scratch things out back in those days. So they literally had an underground hit and had 500,000 records sold with no promotion, none of all the bells and whistles. And that's where you are now. If you were willing to put in time to promote digitally your product, you could be there too. Some of the most recent recording artists that got deals was because they were underground. They had a big following underground, and then the record companies approached them, and they have to give them 7 figures in, because why am I going to leave a situation where I'm getting paid directly? I have 100% control over everything. I don't have to argue with the record company whether this is a single or that's a single, or whether they're going to support me or not. I do it myself. And they have to pay me enough to make it worth my while to give up control, because it's all about control. A lot of it is about control.
And do you find that can be difficult sometimes when it comes to talent, giving up that control when they should? Because obviously it's not always the best to do everything once you've leveled to another, grown to a certain level. People say you should, assign or delegate, art of delegating things to the right people. Do you find that, in your time that because I know you said getting into the entertainment business, and getting art, it was challenging a little bit. I guess explain that, because that seems like that's where the challenge can be. The big head feeling like, well, why do I need an attorney if I'm doing it all myself? Why do I need a manager? Why do I need this?
It's not that they don't think they need an attorney. It's challenging from the standpoint of, say, working for a company, working in-house as a lawyer. Not that easy. You don't find a lot of African American lawyers working in-house at record companies. You find them more at film companies and sometimes television companies, but it's really difficult to break in. And the other thing is that your clients, a lot of times they have some kind of a perception that other attorneys are better, that they should get this one or that one, and they don't realize they're lost in the shuffle with them. And they're not the priority. And they're not treated as a priority. It's like, case in point, let's look at Michael Jackson when he had John Branca as his lawyer. He got really upset and he was blaming Tommy Mottola, but I knew immediately that what happened was what's called a cross collateralization clause, and that's 100% his lawyer's problem, not the company. He had huge bargaining position, and I would never have had a cross collateralization clause in Shaggy's contract. So what happened was, they crossed up the money from ATB Music with his recording contract. Now, why was that really, really problematic? Because he already had bought ATB Music with his own money prior to negotiating the deal with Sony. So Sony wants to administrate ATB on his behalf. And like you said, you have to give up control sometimes. Administration is is tedious, but he could have done it. But administrative deal is 10%. It's a 90-10% deal. So they take 10% as an administrative overhead fee. Somehow there was a clause in his recording agreement that said that they could take money from this or any other agreement that we have with you. They might put that in there 60 times in a recording contract. I will meticulously cross it out every single time I see it.
Wow.
Every time. Even though they might say, well, it doesn't apply to this. I said, you know what? I don't need that clause. It has to go. It's just too difficult to, to rein that clause in, because anytime it's there in any place, they can take money from another. So basically, a recording contract is recoupable but non-refundable. It's non-returnable. So if they give you, case in point, there was a group back in the day. They got $1 million deal, and they got their first half. The first part of the recording agreement was for $500,000. They were a rap group. They left the country. They couldn't believe they got $500,000, and they thought they would have to give it back. Not only would they not have to give it back, if they just did anything and turned it in, they could have got the other half. But they just thought, hey, somebody gave us $500,000. We're taking this money and running. But it's not returnable. It's recoupable against record sales, but it's not refundable. You don't have to give it back to them. They can't ask for it back once they give it to you.
Have you dealt with the situation in entertainment? And then I'm going to pivot into some of the other things that you also are expert in. But have you ever dealt with a client that has got to a certain point where they were too big for you? I've heard attorneys talk about that.
No. What do you mean they were too big in their mind? Too big for me?
Like they felt like, okay, you're out of my league. You're getting deals that are, bigger than I'm normal to. I don't want to mess it up. So I think you should be with a bigger attorney, or an attorney that does more of these type of scale of deals. Have you dealt with that?
What happens is they mess themselves up with that. They think that if they go to a larger law firm, they're going to be better off because they'll sell them on the fact that they can do all these things for them. Case in point, let's look at, I believe it was Marvin Gaye, his lawyer. A big law firm tried to take him away from his lawyer. And he brought his lawyer to the meeting. And the meeting was about, hey, you could use the corporate jet. We've got brass, we've got brass handles in the bathroom on the knobs. We've got, brass toilet seats. You know what I mean? Right. We've got all this stuff, and we could do a better job for you because we just have more resources than your small little attorney does. And so Marvin said, okay, so what if I got picked up on a DUI and I'm in jail and it's 3:00 in the morning? Would you pick up the phone if I called you? Well, no, we don't work at that time. We don't do criminal law. Okay. He said, well, my attorney has done that for me. So what if I couldn't afford to pay you, but I needed to have this contract done? What would you do? Oh, well, we'd have to pass on that. He says, okay, well, see, no, my attorney wouldn't do that to me. So I'm going to pass on the brass toilets and the corporate jet and go with somebody that actually has my best interest at heart. Right. I love the fact that he was loyal to his attorney, because I have had the opposite happen to me many times, and they don't realize. And they come back later when I explain to them what's going on and how this divide and conquer thing is going, only because they're concerned that I'm coming at them, that I know where the money is, I know where the bodies are buried, I know how to negotiate this contract, and they know that I'm coming at them. They figure, hey, get her out of the picture, somebody that wants to work with us and is going to be friends with us and do sweetheart deals with us, like what happened with Michael Jackson. Somebody that's going to play ball with us, because there's a lot of conflicts of interest in this area of law. There's a few attorneys that seem to do everything for everybody. They tend to represent the record companies as well as the artists. So there's a lot of conflicts of interest. And so you can't expect for them to do a deal that is 100% in the artist's favor when there's so much reasons why they might want to be friends with the record company. They have other deals they have going with them. They have other people they want to shop to them. There's a lot of reasons why they might want to cozy up to the record company.
That's interesting. Now, obviously, as an attorney, sometimes you, like you said with Marvin Gaye, that person also has to believe in you as well as them believing in you. That attorney has to see something. How often do you see the it factor in people? And has there been someone like a Shaggy that you were like, I want to work with them because I think that they're a star and I can help whatever? Has that happened, or do you see that happen? What's your experience there?
Well, pretty much a lot of artists that I work with, if I decide to work with them and they don't have any money, that's pretty much probably the reason why. Is because I believe in them. I'll tell people if I'm not passionate about your project, then I can't shop it because it's going to come through. I can't, I kind of wear my emotions on my sleeve. So I can't, I'm not going to be able to lie about it. I'm not going to be able to be enthusiastic about it. And another thing is that if an attorney is shopping product, they have to have good ears. So I'm not going to take something in that I know I don't believe in. Maybe it's good. Maybe someone else likes it. So that doesn't mean it's not a good project, but if it's not a good one for me to work on, because I don't, if you're just going to pay me to do the job, I'll do the job. But as far as shopping something, I'm not going to shop it because I have to maintain that reputation that I have good ears. Because I've had people call me and say, hey, what do you got? And I said, well, what do you mean? What do I have? And they go, well, everything you've given me has been really good. I want to hear what you have. And I'm trying to always chase these people down back in the day to get a meeting. And here's people calling me, asking me what I have. And I'm like, okay, this is what I'm shopping right now.
Gotcha.
And it's because they felt that I had good ears. And so if I give them something that is garbage or that brings them problems, they're not going to want to deal with me again because they're going to remember, oh, she's the one that brought the deal, but the contracts weren't straight, or somebody else claims that they wrote it. And we got into all this trouble. And no, we don't want to do that.
Completely understand. So let's pivot a little bit to, as a litigator, you mentioned earlier about your litigation skills, and it seems like you don't mind getting in the courtroom and fighting. I know sometimes on the entertainment side, that is not always the case. You're more dealing with contracts and negotiation skills, but in the civil and the criminal aspect, you are actually having to get in and put on your heels and your boxing gloves and go in and defend and or protect. What is your approach there? Because I know some people, they get a pimple when they come from entertainment to the civil courtroom. And then some people are like, I'm fired up, let's go. How do you approach the litigation aspect of attorney advocacy?
You have to be aggressive. You have to not be afraid to paper them, basically. A lot of times, especially with the prosecutor, they're not used to a lot of motions and they're not used to going to trial. To be honest with you, 3% of their cases actually go to trial.
Oh, wow.
So if you threaten them with trial, they hate to lose. Mostly it's plea bargaining, and that's how they're able to stack all these bodies in court, especially African Americans, because the stakes are high. A lot of times they're very biased. A lot of times their people will lose and they might not be guilty, or they'll up level the charges to and make them a lot higher than they should be, so that if a person takes a deal early on, they're going to do so much time, but that's a win for the prosecutor. Every plea bargain is considered a win. Every time it's considered a conviction for the prosecutor. And they're keeping score. It's like a game for them. It's like, hey, I want to win. And sometimes they lose sight of the fact that they're the gatekeeper, and they can dismiss a case if the evidence doesn't show that this is the right person to prosecute, or if there's some problems with the case, they actually hold the key to dismiss the case in the beginning. Even at some point, they can agree to dismiss the case, but most of the time, they have a bully pulpit. They know that putting you on the side of the defense table is a very unfavorable place to be, especially in America, because we are a little bit right of center and very authoritarian. People, by and large, they respond to authority, and they think that the police are right. We're
Right.
at a very, very important part of our history right now where we're actually seeing the fallibility of the police. But when I was in the appellate division, I witnessed a lot of the attorneys practicing their closing arguments. And in their closing arguments, they would say, this case comes down to the police officer's word against the defendant. If you believe the defendant, then you're calling the police officer a liar.
Wow.
He is sworn to protect and serve you. Why would he lie? And they
How do
said
you
it
go up
wins
against
every
that?
time. Pardon?
That seems like something that is almost kind of like, how do you go up against that from the stand? And not to pivot, that's a similar situation because I know that you're also in landlord tenant law, and there's an issue that deals with uh, post judgment claims of right to possession
Yes.
that happen a lot. And in those cases, you have a situation where there's already a judgment, and this individual says, "Hey, wait, sir, I haven't just, Mr. Judge, I haven't gotten, I'm live there too, and what's going on?" So now you have this judge that it has against him. Do I cancel this whole entire case, or do I let this person in and start over, and et cetera, et cetera? If you could explain that process, because it seems like it's kind of similar, that this is what happens, like you said, in the appellate court, it always ends to, if you don't believe this side with the money, or this side that's supposed to be right, then you're you disbelieve in this side, and it hurts one or the other. What are your thoughts as you compare the two?
Well, what they do when they serve you with the unlawful detainer complaint, they name Doe defendants, and they also have attachments, up to 8 attachments that you're supposed to file if you're a Doe defendant, if you have a post judgment right of possession, or if you are, or you have some kind of claim, then you should also sign on to that. They they actually try to go after all the Doe defendants and name them all. Sometimes people actually bring people in that are totally unknown. That's why they'll say you can't sublet, because some people will
Mm-hmm.
sublet. Some people will bring in their boyfriend, their girlfriend, and other people that are not known to the landlord. So they always put in something about Doe defendants. And there are some very aggressive defense lawyers that have been able to, how can I say this, string these cases out for a long time. One of the ways they do that is by requesting a jury trial. It's very difficult to impanel a jury. And so it was taking up to 6 months. And there was a firm called Basta that was really good at that. They started that, asking for jury trials, and everybody else jumped on the bandwagon. There's
Mm-hmm.
also a lot of other defenses that people can bring out, like systematic code enforcement violations. The rent stabilization ordinance is very specific. If a property was built before like 1972, then that property it has certain things attached to it. If it's a city in Los Angeles,
Mm-hmm.
you have to give people relocation expenses, which have gone up a lot. If a person is over 62 or they have a disability, the relocation expenses right now are like 18,500.
Wow.
And for the average person, it's like 8,000, between 7,900 and 8,900 for relocation expenses per person. So if you have two people in an apartment that's subject to rent control, and you want to get them out, you might have to pay relocation expenses.
Interesting. And I want to go back to the unlawful detainer thing more specifically, but I know that I was listening to something that you mentioned in an interview before, that you had said about a cheat sheet that you started when you were in law school that helped you through your cases, that you implemented when you were in law school. Can you kind of explain how you still utilize that cheat sheet for when you're assessing a case, whether it's criminal or civil, how that applies to your practice still now?
Well, actually, in that context, the cheat sheet was for passing the bar. It
Oh, okay.
was, how do you analyze how do you spot the issues, and how do you analyze a case? Because really, law is it's a mental boot camp. It's just like when you go to a training camp and it's physical. This is a mental boot camp, because what they're really trying to do is teach you how to think a certain way and analyze a problem a certain way. So they want you to spot the issues, and they want you to, no matter which side you're on, because the more important thing in litigation is to anticipate what the other side might do. And that's why it's important, especially in criminal law, but in all areas of litigation, for you to be honest with your attorney. Your attorney's not the judge and jury. Even if you're guilty, especially if you're guilty, you need to tell your attorney. It's not that they're going to make a judgment on you, but what's going to happen is you're going to be blindsided with something that the attorney might have been able to finesse eliminating for some kind of an evidentiary reason, may be able to stop the other side from getting to that evidence. And basically, if they can't admit the evidence in court, then it doesn't go to the jury. And then the jury can't use it to consider whether you're guilty or innocent, or whether this person, whether it's a civil matter, they can't figure that out. So I've seen some attorneys who were really good with the evidence code and literally shut an attorney down because they objected so much, and the other attorney got flustered and couldn't figure out how to ask the question in a way that it would be admissible and how to get the evidence in. So you have to know that evidence code backwards and forwards. You have to lay a foundation. You have to know what you're doing when you're questioning people, so that you can make sure that all the evidence to make your case is admissible.
Can you explain what the 1983 Civil Rights Code, how that applies? I mean, I heard you talking about that, and I know it's something dealing with civil rights, but can you just explain a little bit what that means and how that's applied?
Well, the Civil Rights Act, this was passed right after the Civil War, actually, because they were trying to level the playing field for African Americans that were actually, so it's not the 1983 Civil Rights Act, it's called Section 1983. And I'm going to guess, I'm not exactly certain when it was passed, but it was like something like 1868, or, it was right after the Civil War. And it was to give African Americans, or at that time, we changed names so many times. I actually like American descendants of slavery better, because African American is a immigration term which somebody like Elon Musk would fit under African American. He's from South Africa, he's from Africa, and he's American. So we think of it as a black person, but in actuality, we're a specific class of people which are American descendants of slavery. So, and that's significant because Section 1983 was actually supposed to help level the playing field for people that were American descendants of slavery, by helping them to be able to compete for government contracts and to be able to contract and be able to transact business. And that's why the Comcast case was so important. Byron Allen brought the case because he was saying that he was being discriminated against in a commercial contract, which was his contract to distribute his product through Comcast and other such outlets. Technically, this is where we get on. This is a pet peeve of mine. I've never been a friend or a fan of the Supreme Court, period. The Supreme Court might as well be called the white supremacist court, because it has promoted white supremacy from the very beginning. In the judge, basically Plessy versus Ferguson was a case that was, it was heard right after the Civil War. There was a light-skinned black man that was riding on the train, and he was upset because he was separated, and this is when they got the doctrine. The doctrine of separate but equal was started by the United States Supreme Court. So every time we get the 13th, the 14th Amendment, or Section 1983, the Supreme Court has narrowly construed it in such a way to continue to make black people second-class citizens in this country, and to continue to snatch them back into slavery, okay? Because they had a chance with Plessy versus Ferguson, and they said separate but equal, and they even went further. The Supreme Court even went further. The Chief Justice stated in that case, a black man has no rights that a white man is bound to respect.
Oh, wow.
That unleashed the KKK on us. That's when Jim Crow laws became the law of the land, because they realized that the United States Supreme Court sanctioned it by saying separate but equal was okay. And that's what Jim Crow was about. Remember, you had a separate place to eat. You had a separate place on the bus. You had a separate drinking fountain. Separate but equal. And it went on until 1954 with the Brown versus Board of Education, where they said separate is not equal.
Wow. So now I remember you telling about a story when you were younger, and you were pulled, the police were following you, and you kind of got frantic. Can you kind of tell us a little bit about that story and how that impacted even your today, and when you think about these experiences?
Well, I had a couple of experiences. One was when I was a little girl. My father is dark complected, and I was in the car with my father. I was probably about eight years old. I'm in the car with my father, and at that time, LAPD, they used to recruit from the South, and they had these guys that it was about 10 o'clock at night. They stopped my father. They were calling him the N word. They were cussing at him, and the tone of their voice and everything was upsetting to me. So I started crying, and I said, please don't kill my daddy. And they flashed a flashlight in the car, and they saw me in the passenger seat, and they said, oh, there's a little girl here. Okay, leave him alone. Now, what would they have done if I wasn't there?
Wow.
So flash forward to I'm about 18 and I'm driving. I'm in South Central Los Angeles and the police chase me. And it's about 2 a.m. in the morning. I'm coming back from a party, but I'm by myself in the car. And I've just been reading all these things about how the police have been raping women and doing all these crazy things and hurting people and police brutality. And I also read that you can go to a place that has lights and witnesses, so you don't have to stop immediately when the police come after you. You can drive until you find a place where there's witnesses and lights so that people can see. So that's what I did. I ran from the police and I was terrified of them. And so when they finally caught up with me, they were screaming at me and I just burst into tears and started crying. And I said, you're going to kill me. You're going to rape me. I know you are. They go, no, we're the police. I said, I know. And they go, no, we're here to help you. I said, no, you're not. You're not here to help me. You're here to kill me. And you're going to rape me and kill me. And they were like, this girl is crazy. So they finally let me go. But I really was terrified of them. And it reminds me, recently I saw on Facebook where a little black kid was crying when she saw a police officer drive by. And it was the cop was a female white cop. And she stopped. And she talked to the little girl, and she said she felt really bad that this little girl felt this way just by seeing her. But I can tell you that it's a visceral reaction that a lot of people have. A lot of Black people have that feeling when it took me a while. I mean, only recently did I get to the point where I don't have this visceral reaction when I see a police officer.
That's interesting. Let me ask you this. Are you hearing me? Feedback. Are you hearing me?
I can hear you.
Okay. Someone coming to California new, what do you tell them to protect themselves? This is a social media question. Like what should they know?
Wow, there's a lot of things they should know. Okay, so whenever you call the police, you're at risk of being taken into custody, even if you're the victim, if you're Black. Case in point, I had a client recently who came out here to visit a guy, and somehow everything got turned around. She wanted to leave this person, and the person was very aggressive and didn't want her to leave, so locked her in the bathroom, all this kind of stuff. She finally is able to call one of her relatives who calls the police, and the police come and they take her into custody and charge her with multiple felonies.
No.
And she's the one that called the police. So it's very interesting that could happen, but that's not an isolated incident. This type of thing happens all the time, and it's something that is unfortunate. But you know, domestic violence is a huge problem here. Just you in California, you don't have to. Also, another thing is a lot of the reason why African Americans go to jail because they have inordinate conduct with the police. The police are constantly coming, stopping them, frisking them, constantly coming to them, trying to see if they have committed a crime, want to run their license. You don't even have to give them any information. You don't. In California, you don't. You can ask them, am I being arrested? Why am I being detained? Am I free to go? Should I call a lawyer? I'm invoking my Fifth Amendment right to call a lawyer. A lot of people think, a lot of Black people, a lot of white people think that the Black people are getting in trouble because they're refusing to cooperate with the police. We see what happened to George Floyd. He cooperated and he got killed. I'm not saying don't cooperate, but what I am saying is that sometimes if they know you know your rights and stuff, they think twice about it. you know, they think twice about it. But always make sure that you look at the cameras around and stuff, because sometimes they'll get you for using your cell phone. They'll claim that you're obstructing justice when you're exercising your First Amendment right. They'll try to take it away from you. They'll try to stop you. And a lot of times they'll say, not a lot of times, but technically they're supposed to have their camera on at all times.
Right.
And somehow it'll get turned off, usually at a crucial time. I had a case the other day, about a few months ago, before this pandemic, I call it, but anyway, before this thing started, I had a case where I was in on a Brady motion because all of the evidence from the CHP was destroyed. The 911 call, the body cam, the MVARs that are on the vehicle, and the CHP doesn't have body cam, but they have an audio recorder that they have on the side. And my client told me that the whole time that this person was talking to him for 2 hours, he constantly put his hand over the audio. Every single time he talked to him, he put his hand over the audio. So I'm in court with the judge, and a lot of the judges, as I told you, are ex-prosecutors. So I'm telling the judge I'm having a problem with not being able to get any of the evidence. This perfect storm happened where everything got destroyed. This guy claims he stopped my client because because there was a call about an accident that was called in, but he really stopped him for driving while black. He was on the side of the freeway and he was changing his tire, and there was no accident call. If there was, we would have picked it up on the 911. Of course, they say that was purged. Now, how is that? So the 911 call isn't there. This officer has covered up his audio, so it's garbled. So they said, oh, we can't detect anything, so we're not going to give you that. And then his MVARs, which are the moving vehicle, the motor vehicle camera that's on the front of the vehicle,
Right.
that's also disabled. So there's no video at all. And so I said, well, I got frustrated because I said, okay, none of this is here. I said, I want the training, man. You know what? I said, you know what? I'm going to ask for a continuance because I'm going to subpoena his training manual and what his training was and what the instructions and policies and procedures of the CHP regarding turning off your MVARs, turning off and covering up your audio. I want to know if he was trained to do that, if this is something that he was trained to do. If he wasn't trained to do that, he wasn't following his procedures, and that he should be, punished for that. That we were going to do an internal affairs complaint because he did not follow the procedures that he's supposed to follow. Then the judge is like, he starts shaking, but the judge is like, well, just get over it because we just don't have it. Get over it. We've got the officer here. And I said, that's exactly what I don't want to do, Your Honor. I don't want to rely on an officer that may be lying. I want to rely on the objective view of the cameras. I want to be able to compare that to what the officer says, because my client's story is totally different than what the officer's story is. And now we don't have the cameras to see who's telling the truth.
Right. And you say that's a Brady motion that you ended up filing, correct?
Well, a pitches motion is when you ask for their records. The Brady motion is when exculpatory evidence has not been turned over. And it's when important evidence has not been turned over, it is assumed that the reason the prosecutor didn't turn that evidence over is because it may be exculpatory. In other words, it may lead to a not guilty verdict.
Gotcha. Limited scope and full scope versus full scope. What's the difference and how does those work?
Well, in order for people to be able to afford attorneys, the California State Bar created something called a limited scope agreement and a limited scope representation. So now you can actually go into court, and when you do a substitution of attorney, you can substitute into a pro se or a pro per case and on a limited scope basis. And you can say, I'm here just for this appearance on behalf of the client, or I'm here for this appearance through the order being granted. So say you're in a family law case and somebody wants to have an RFO, a request for order, to change custody, change visitation, or change alimony or support orders. They may hire an attorney on a limited scope basis, and the limited scope basis may be to represent them one time in court to argue or to prepare the motion and see the motion through, which may take 1 to 3 appearances in court. But they're not taking over the entire case.
So what would you say to somebody, let's say in criminal, they can only afford a public defender, which obviously is given to them, but it's usually from a budget perspective. What kind of questions should they ask that attorney to make sure that that attorney, that public defender, has their best interest, or they're not just considered a number? Is there any way to get around that, or are you just stuck?
You're stuck. If you get the public defender, it's very hard to get a different public defender. And unfortunately, that's just the way it is. But they can be, any attorney is susceptible to a claim of ineffective assistance of counsel. And if something happens, say you get convicted or you want to do a habeas corpus, your habeas corpus brief would be on the basis of ineffective assistance of counsel.
Hmm. Okay, now you have your hands also in immigration law. If really quickly, if you can kind of sum up or give us a brief understanding on what someone coming into California in general should know as an immigrant coming here to protect themselves, what would you say to them?
Well, in the immigration, it depends on what their basis for immigrating is. If they're coming in because they say they are seeking political asylum, then they're subject to the International Convention Against Torture. And they're supposed to be able to come into the country while they're and we as the United States are mandated to accept their asylum petition and hear their asylum petition. But many times it will not be granted. A lot of times they will be deported, but that process can take 2 to 3 years. If they're coming in and just immigrating, it depends on what status they're immigrating under, whether they're coming in under a marriage petition, whether they're coming in as a business person that's investing in this country, or whether they're coming in as somebody with a specialized skill, like people that are recording artists or they work in the tech industry. They'll come in with a specialized skill. And so there's different requirements for each type of visa that you're seeking, and each type of, you want to get a green card eventually, but there's different requirements.
Understood. This is a social media question. Now, I know that you're also in the cannabis industry.
Yes.
Someone wanting to join the cannabis industry, okay, I want to grow my own plants. I want to get started. I want to do this. What they come to you, you overhear the conversation. What do you tell them first? What advice do you give them?
Well, that's a tough one because some places have what's called social equity, and some of them are a lot of the cities. So in California, you have to have a local license first before you can go for the state license. And there's different criteria that each different locality or city, municipality has for that. So like right now, I'm working with the city of Sacramento, and they want to do a merit-based application. They were going to do a lottery, but people weren't happy with that. And by and large, most people are not happy with lotteries because they feel like it's like the luck of the draw, and it seems to favor people that have a lot of money. But when the state of California voted for Prop 64, there was a part of it that said that they are going to be, one of the main reasons they're legalizing marijuana was because of the war on drugs. It had disproportionate effect on African Americans and some Hispanics, but the bulk was African Americans that went to jail for things like having 3 joints and being considered possession for sale, and going up to the state prison for felonies based on having 3 joints in their pocket, which some people might consider that personal consumption.
Right.
And so a lot of people were railroaded into jail. And this was something to level the playing field, but it had a devastating effect on the community. Recently, in 2018, I took a class because I was interested in getting a urban policy degree from the Kennedy School at Harvard. And I took a class, and my thesis was on cannabis, social equity in the cannabis industry. And I pulled the policy map of the area that I grew up, which was 90011. And when I pulled the policy map and looked for data to see how much an African American male would make, because they're looking at poverty, they're looking at arrest rates. This is what they're looking at when they decide which areas are impacted by the war on drugs. So in that zip code, the average annual salary of a 30-year-old male African American was $6,500 a year.
Wow.
That should tell you something. How can you be a meaningful factor in your family's life? How can you take care of your kids? How can you take care of yourself? Is it a surprise that most people, most of those guys that are that age are homeless and they're part of the homeless population? It shouldn't be a surprise that they're locked into the criminal justice system. I had a substance abuse clinic on 48th and Crenshaw, and I used to tell my clients, you're spending a life sentence on the installment plan.
Wow.
Because you're going into jail for 3 years, you stay out for 2, you go back for 2 or 3, you go, it's just back and forth, right? Until you finally get the 3 strikes law applied against you. 3 misdemeanors equals a felony. Eventually, these recidivism laws, 25 to life. The 3 strike law is 25 to life, which means they can put you in for a life sentence.
What?
All they have to do is say it's 25 years, and then every time parole comes up, they deny your parole, and that becomes a life sentence. But 25 years is technically a life sentence. And for what? For doing not even that much. Doesn't even have to be a violent crime. When I explain to people that it doesn't even have to be a violent crime for you to be in jail for the rest of your life, people are like, oh, I just assumed that it was violent criminals. No. 3
That's
felonies.
interesting. Now, you say you have a substance abuse. Now, going to the homeless, obviously you work in the eviction area, you deal with substance abuse. Homelessness is a big deal. From my time, I started a nonprofit called Hope for Tenants. I've been in the area for about 10 years or so. So my issues, I've seen that with over 60 to 70,000 in Los Angeles County alone, eviction cases that happen. And, 99% of these people don't have representation. So they usually lose their homes. What do you feel the court plays in far as in with homelessness in Los Angeles? And do you think that there is a solution that can be, that can happen? And I only say that because it seems like the landlord-tenant laws are for the tenants. However, the judicial officers are not necessarily following those. What was your experience in watching that or seeing that?
My experience is that a lot of the judges, they may be homeowners, they may be landlords. And they try to find a way to side with the landlord, actually. I'm not trying to be mean, but they do try to, what I've seen is they try to find a way to side with the landlord when the law may clearly be in on the side of the tenant, right? For instance, there are new laws that came into effect on January 1st, which says that you have to have just cause to evict. That raises the bar quite a bit. Just cause to evict someone, not just that they didn't pay their rent, but you have to have just cause.
Is that not just cause?
Pardon me?
Is paying your rent not just
Not paying
cause?
your rent?
Not paying your rent.
Right. Not paying your rent would be just cause, but there's other, sometimes they will evict you for a covenant. They will evict you for, like I had a dog one time and she tried to, my landlord tried to evict me because of the dog. And then she ruled the day she did that because I was having lunch with the chief inspector for the building and safety. And when I got the letter from her, he saw the look on my face. He goes, "What's wrong?" And I said, "I just moved to this apartment and I agreed to allow her time to fix things that I know are, need to be fixed. But now she's saying that she's not going to prorate the rent." And, he goes, "Oh, no problem. What's the address?" He sent over a building inspector. She had 28 systematic code enforcement violations. It took her a year to clear all those code enforcement violations.
Wow. Wow, that's very interesting that you even mentioned, knowing and seeing that. Now, the Jameson versus Disaster case came in 2018, which was a landmark situation, I believe, for the unlawful detainer courts, because for the first time they actually put in electronic recordings. There was never any record unless an individual paid for it themselves, meaning a transcript, and then most of the time people couldn't afford that. In your time in practicing law, has that been a beneficial thing, having access to those recordings or knowing people having access? Has it shaped anything, any type of transparency, having now recordings in those courts versus not, in your opinion?
Recordings on the part of whom?
So in every unlawful detainer courtroom, starting in starting August 2018, the Jamison versus DeZessa case forced that the court had to put either electronic recordings or provide a court reporter in the courtroom.
Oh, yes,
And
to
so
record the proceedings.
correct. So
Yes.
every unlawful detainer courtroom has audio going in it, and you can now order those for your appellate review. Um, I guess I'm asking, I guess in general, with having a court reporter there or having a record there, do you find where it keeps the judge more honest, or do you find that that doesn't work? How do you keep the judge honest in a court case, in your opinion?
So most people are not going to appeal, and they're not going to have the money to appeal. Appellate lawyers are a specialized skill. You have to actually pay. The lawyer that you have may not appeal. You might have to hire a different lawyer for the appellate portion of a case, and they are specialized and they charge a lot of money a lot of times. So it's highly unlikely that they're worried about an appeal, because a lot of people are not going to appeal, especially not in those type of cases. Now, there are, like you mentioned, eviction defense network. There are companies like Basta that may appeal because that's what they do, and they're in the ACLU. They may appeal if they're on the case, you know, just because it's something that they do all the time, and they're a pro bono law firm, so the person doesn't have to pay them to do it. But if you had to pay an appellate lawyer, then that would be further. It's really hard for people that are already indigent. And we expect a landslide of cases to come up, because right now, a lot of landlords have been pissed about the moratorium, and they have really been chomping at the bit to get into court. And October 15th is a D-Day. October 15th is the day that they will start accepting more unlawful detainers. And the way the law was written, it wasn't a forgiveness. It was just a suspension until later of the right to pay the rent, of the ability to pay the rent. So the problem is that a lot of people were unemployed. There's nothing, there was just recently there was a prop, I think it might have been 21, but don't hold me to that, that said that people had to accept people back to their job, especially in the hotel industry. Now that's a union type of rule. If you're subjected to a union, then yes. If you're laid off, then you have to be given first dibs, right of first refusal for your job when that job becomes open again. The problem is that the hotel industry and a lot of those industries have lobbied saying, look, we don't know when people are going to start coming back, and we don't want to be obligated to hire a full crew when we don't have a full complement of people in our hotel. The problem there is that this doesn't protect the jobs, because when they do hire, they don't have to rehire the people they had before. They can hire a whole new crew. And this is why the people that were there before are upset, because they don't know what their job security is. So it's all up in the air. I expect there's going to be a record number of foreclosures and evictions next year. The reason why I call it a pandemic is I know there is really something going on, but it's something that is being taken advantage of because the economy had tanked already.
Right.
And if you notice, Trump is saying that in his campaign materials and his campaign commercial, he's saying, hey, I was real good on the economy, and people are saying they trust him with the economy. Well, he broke it. He's like Wreck-It Ralph. Wreck-It Ralph broke the internet, and Wreck-It Trump broke the economy. Okay?
Right.
He wrecked it. Just like he did with every business he's ever had. Bankruptcy is his exit plan. It's always his exit plan from every deal he's ever done. Because I used to do construction litigation. It's his, and I used to I remember when I first started, before I worked, the first job I had actually out of law school was construction litigation. And I educated the judge in Orange County about the fact that most of these developers were, in order to do your next development, you have to put down a quarter of the money. So what they do is, it's funny, but coincidentally, you pay your contractors, your subcontractors are paid in quarters. They're paid in certain amounts. You got to pay a quarter up front. Then, they finish this much, then At the last part, they will always claim that the subcontractor did something wrong, whether they did or not, because they're buying time. They're taking that money that they already got from the bank on this project, and they're bankrolling the next project by putting the quarter that was left to pay these people off. They're going and taking it to the next project. And then they're going to the subcontractor and saying, hey, I got a new job for you. Forget about that money. And eventually the balls are going to drop. And that's what happened. Eventually they declare bankruptcy because eventually the housing market tanks and that last quarter never gets paid to the subcontractor. But they keep chasing the developer around because they keep telling them, hey, I can't pay you that, but I got a new project for you. Come over here, forget about that, and I'm going to pay you on the next one. And that's been his exit plan on every project, and including the United States of America.
How often do you have to educate a judge? And is it unwise to not think you would have to do that with your case?
You always seek to educate the judge, but you do it in a subtle way. A lot of times in the pretrial motions, you do those motions and you write your complaint in such a way that it's a story, it's telling a story. That's why there's so many legal programs on, because literally you have to script it like it's a story. You have to make it engaging so that people will buy into your side of the story because it's persuasive. You're persuading them to vote your way. And it starts with persuading the judge.
What is the difference between the appellate court and the appeals court?
Oh, they're the same thing. The appellate, what happens is when you appeal a case, the only grounds upon which to appeal the case are the objections and the sustained. So when you object and the judge sustains it or overrules that objection, your appeal is based on whether or not the judge made the right call from the bench based on the evidence code and case law precedent. Did the judge make the right call? And if he made the wrong call, would it have materially affected the case such that the case would have been decided a different way? That's your basis for appeal.
Now, obviously, I've dealt with the appeals process, and technically it is a brief, a responding brief, and then a reply brief, right? Which is
Yes.
technically the process in most motions that you file if you're an attorney. Why is it so significant to where in an appellate brief where you file, they want to charge thousands of dollars for one brief and one basic motion, but then on the over here they'll take a whole case for 5 years and do it on contingency, but on here with one motion on the appeals they'll want to charge you thousands of dollars. I guess help me understand what is the real difference. It would appear that an appeal would be easier if you got the record than it would be filing the original motion. Help me understand this.
Well, it's a specialized area because remember what I told you, the only grounds for appeal are the judge's rulings from the bench, whether or not those rulings would have changed the outcome of the case. So you have to be very specific. Also, attorneys only take contingency matters when there's money on the other end and where they're looking, and they have to vet that case because if I take a case on contingency, I've got to be willing to invest in that case, not just my time, but my money. Cases are won and lost by the experts. You have to get forensic accountants. You have to get experts to reconstruct an accident. And you've got to pay those guys up front. And you also have to pay their witness fees for them to come to court and testify. That can be a lot of money. The only reason an attorney would bankroll that is because they see a lot more money on the other side. But we've made mistakes and lost. And then it's a gamble. So you want to make sure that the risk reward is there. And in that case, you'll take a contingency matter. Like for instance, I have a case where a client was T-boned and she's the passenger in the car by the CHP. They didn't have their lights on. They ran a red light and there's witnesses. Bam. Easy case to take because she can sue the driver of the car, even though the driver wasn't at fault, can sue the CHP. There's witnesses, it's clear-cut liability. But in another case, just because a case is a rear-ender case doesn't mean the liability is 100% clear-cut. You really have to look into it and make sure, because we have what's called contributory negligence, and we want to make sure that we have a clear-cut case that we can make, money on. So you don't want to put a whole bunch of money into it. Right now, insurance companies are extremely aggressive, and even though they're going to lose, they make sure to make it something that you had to put so much money up against, and maybe you don't make them enough money. Maybe you'll walk away as an attorney. Maybe you'll say, hey, you know what? Next time I'll think twice about suing the insurance company, because even though I won, it was a Pyrrhic victory. I didn't really get as much as I wanted, or maybe I'm upside down. Maybe I invested more in the case than what I got out of the case, and I'm not going to be doing that again, because you can go bankrupt doing that. But in the case of an appellate, there's no money on the other side. You're just appealing. So that's an hourly rate. I'm going to charge you an hourly rate to write an appellate brief. And it's going to be a little more involved than your normal motion, because you have to go by case law precedent in the appellate court. And you have to be an expert on the evidence code, and you have to make sure that, you look at it and see what did the judge rule here and there. And you have to be able to persuade the three judge appellate panel, that this would have gone another way, that the judge A made a mistake, and B, it was not a harmless error, because the Supreme Court has said there's harmless error. So, okay, judge made a mistake, but it was not material. Would have decided the thing the same way. The case would have gone the same way regardless. So there's two hurdles. Did the judge make a mistake, and then was it a material mistake such that it would have changed the outcome of the case?
Okay. So we're going to be wrapping this up, because I know we've been at this a while, and thank you. So, but just to piggyback off of that, I've heard people say, and I've maybe heard you say, a person that hires themselves as their own attorney has a fool as a client. However, what I have learned in that capacity, that only comes down to if you were, let's say, a former attorney, or if you know the law enough to where you're saying, I don't want to have an attorney in that capacity, or you don't see the need of that. Because what you find is some people really can't afford an attorney. One of the hardest and most tiring processes was actually looking for an attorney. You would think that they all have money and don't need any cases when you're looking for one. I've also found that, and I've seen this in cases to where it's almost like the music industry, where artists will start their own, print up their own CD and start selling it like Master P, and then the record label comes along. I find that has been a lot of the scenario with attorneys in LA as well. As once you file it, they'll come along and amend the complaint, etc. I know some depending on how much you may have done, but what do you say to that individual that says, well, I honestly can't afford an attorney, but I have a statute of limitation where I have to file this document and I need to move this forward, or I'll lose this opportunity? Is that person a fool for moving forward, or should that person do what they have to do until they can get the help needed? What are your thoughts?
Everything's a case-by-case basis, but if you want to preserve a statute of limitations, you can file a lawsuit. A lot of attorneys will not go behind you and amend the lawsuit unless there's a big amount of money. Like, say, for instance, in the CHP case, you have to do that within 180 days. But there's no attorney that wouldn't take that case, because it's a clear-cut case, where you could do a contingency. The problem is that you can do limited scope. That's another thing you can do too. I know what I can do. I do this much as a pro se litigant or a pro per litigant. But then I get to something like I have to go to trial, then I do this. What I don't want you to do is, a lot of times people will get these document preparers, and they will charge exorbitant amounts of money, more money than a lawyer would charge, actually. And there's no recourse against them, because they don't have a license to lose. There's really not anything you can do against them. Whereas if you had a lawyer, they have a license to lose, so they have a certain standard they have to live up to. A lot of these people are just taking people's money, especially in the unlawful detainer area and the immigration area. There's a lot of immigrants, people that don't speak English, that are being taken advantage of by notarios and people that are claiming to be lawyers that aren't.
That's interesting. And family, and like I said, family. Obviously, I know you have family. I'm not sure if you're married or not, but how has that been with your workload and being focused in the law, and also in actually having a balanced family, friends, How does one handle that?
It can be tough, especially when it can be tough. I know that there's time that I would have wished that I had spent more time with my son. A lot of times I didn't work for a law firm so that I would have more flexibility in my time. I could have gone to work for a company or a law firm, but the times that I did, it didn't allow me to spend enough time with my son. It didn't allow me to be able to take him to different places and things like that that I had to do during the day, like doctor's appointments, go to school, see his school plays, or different things that he had going on. And early on, when I was really trying to be in the entertainment industry, a lawyer in that industry, that took a lot of my time. And
Mm.
I do feel that I should have spent more time with my son. I didn't get married. And like I told one of the firms that I worked for, a lot of the reason is because you want me here at 10 o'clock at night. When am I supposed to be able to find somebody? And then people would get tired of me not being able to be there, and so I wasn't really able, so it's hard for a woman in their career. And I've been told that lawyers have a very high divorce rate,
Mm.
even for men, because the hourly requirements are so long. I've actually talked to lawyers at big law firms that are still there. They're faxing me at 11 o'clock at night. They're sending me
Right.
emails at 11 o'clock at night, and then they're back at it at 6, 7 a.m. in the morning.
Right.
So, and this is in the time, this is your childbearing years. This is the time when you're supposed to be finding a husband. How can you do that when this is going on, when you're just married to your job? And so I think people need a work life balance. I think it's really good that people are able to work from home. We've been begging law firms to allow us to work from home, but the funny thing about lawyers is they don't trust each other. So they
Mm.
don't want their people to be working from home because they think, heaven forbid, they might not be working the whole time.
That's interesting. A piece of advice that you received that you pass along to others in life and also other litigants, like attorneys, a piece of advice that you received that you say, wow, and you pass along, what would it be?
I always like to say persistence wins out, being persistent wins out in things. And I'm always very persistent. I never give up. I never give up on myself, on my clients, on anything in life, because I find that things change. And if you can be the last person standing and you win, just by being persistent. So that's
Dope.
one of my main things.
And what is it that you know for sure? 30 years in the business, you've seen a lot, you're super educated on multiple streams of knowledge. What do you know for sure that you would give back to the audience?
Well, I prefer being self-employed rather than being employed by people. The I like the autonomy and the ability to have my hours the way I want them. I know for sure that I should have had more life balance. I'm finding out things now that I wish that I had known, that my 25-year-old self, that my 30-year-old self had known at that time, about work-life balance, about what's really important in life. And it's not really your career. It's really the people that are in your life that are most important, and having the right quality people around you, because teamwork makes the dream work. Together, everyone achieves more. And everyone has this idea, especially like recording artists and people like that, and they kind of have to have that idea, but it's all me. It's all me. Nobody helped me. But it really is a good team. And when you surround yourself with the right team, there's nothing you can't do. There's a Buddhist saying, itai dosen, many in body, one in mind, and there's nothing you can't do.
Hmm, that's awesome. How do people find you if someone wanted to work with you, an artist? Where do we find you at? I'm going to put your website, but just where do we find you? How do we reach you?
Well, you can call me at 877-384-5239. You can email me at Rhonda at DixonJusticeCenter.com, which is RONDA at DixonJusticeCenter.com. You can also go to my website, www.dixonjusticecenter.com. You can Facebook me. I'm on Facebook. You can instant messenger me or WhatsApp me. So, there's a lot of different ways you can reach me.
Awesome. And now, really quick, for somebody wanting to reach you, Do you have a limit on what you take? And like, do you have like a capacity to where you're like, I'm over full, I'm not taking any new clients? Like, how does that work?
It really depends on what the matter is, because even I might be able to refer them to someone else, or it just depends on what the matter is. So I would say just contact me, and then I'll let you know. If I can't handle it, I'll refer you to someone that I know that's their area of law. Like employment law, I usually don't take those cases on. They're complex, and I have people that I send them out to. Sometimes I might send out even a personal injury matter, because it might require a lot of money up front, and I might not be willing to do that. It also, it's not just the money, it's the technical work. It's a lot of paperwork sometimes.
Gotcha. I just want to tell you so much that I appreciate you coming on and being so candid with us. There's so many things that I still want to ask, but
Oh,
obviously,
thank you.
we'll be sitting here all day long, and you'll be ready to take a break, a nap in the middle of this. And but I appreciate you explaining yourself and going into details for the camera. I would love for us to continue to do this. I feel like you're one of my experts. I'm just gonna put it out there because you have
Thank
so
you.
much knowledge in this area, and you have so many stories that I think people need to hear, want to hear, and those stories help people put things into to perspective even faster. And so I really thank you for allowing yourself to be used to be a beacon to transmit this kind of information to people so they can understand it, and that's very important. And so again, I thank you so much. What I'm going to do is I'm going to put you in the back. I'm going to close the show out, and then I'm going to come right back to you. But again, thank you for coming on to Inside
Thank
Law
you.
with me and taking this time, because I know you got a lot going on this day, and you brought it with us, and we appreciate it, and we're going to appreciate it for many years to come. So thank you so much on that.
Thank you for having me.
Thank you so much. Definitely. Everybody, you've seen it, you've heard it. That was such an amazing show. I've learned so much. As I was telling you, I was finding questions, and questions were coming up in my mind. There's still so many questions that I have, but I mean, there's so many answers that have been answered for me as well. And I know that they're going to be answered for you. Stay tuned. Remember, as I always say to each and every single one of you, where your mind and your heart goes, your body will follow. Remember, knowledge applied. You got to apply that knowledge. And as I always say, you have to have the courage to take what you know and apply it to your life to get the results that you're looking for. Until next time, this is Inside Law. I am your host, Brookshire. I do look forward to seeing you guys again on our next episode. Until then, peace.